if the case is rejected in an application, and how do you get those? What is the disposal of property and what is the manner? Section 451 primarily deals under the Criminal Procedure Code of Criminal Procedure. And keeping in view the important aspect, we have requested Mr. Angadi, a former district and session judge, principal district session judge from Karnataka, to take his insights. All his webinars are doing extremely well on the Beyond Law CLC YouTube channel. If not subscribed, you can subscribe to that. And we would also like if you can comment upon them as to how did you find the speaker or what topic you want. We will cherish that. Without taking much time, I will ask Mr. Angadi to share his knowledge on this important aspect. Over to you, sir.
Namaste. Good afternoon to all. Thank you, Sri Vikas Sarath, my esteemed viewers, jurists, advocates, law college students, and also the public in general. The topic is very vast. Topic is very interesting. The main thrust is if the police seizes any property from any person in any offense or a criminal case, how the person being owner or agent of the owner or even a financier or even a third party can lay claim from the court and ask the court to grant to him interim possession of the seized property by the police or by various authorities. This is a very important question with which the trial courts every day infrequently deals with, especially those courts who work as magistrates or CJM or court of sessions, and even the high courts also on the revision side or appeal side also hear and dispose of the matters challenging order of the trial court or the court of revision regarding allowing or dismissing the IA filed by the applicant for release of the property seized as an interim measure pending disposal of the case. We have got here sections 451 to 459 of the Cr.P.C, and the very important are 451, that is 451, 452 and 457 of Cr.P.C. So there are chiefly two types of IAs which the applicants may file. Firstly, seeking for interim release of the seized property, where the IO or the police have seized the property and have produced the same before the court by submission of property form. The short form is P of property form. That is the first segment. Section is 451 of Cr.P.C. The second point is there is seizure of property by the police, but the said thing of seizure is not, the thing seized is not produced before the court. So 451 deals with seizure of property. Number 2, property produced before the magistrate. In case of 457, property is seized, but the said property is not produced before the court. So court is not the custodian in the second case. The first case, court is the custodian of the property. That is the important things with which we are concerned. My focus is to deal with the aspects of the case laws of the apex court or the principles which the courts must keep in mind before allowing or disallowing the claim made by the applicant or applicants or rival claimants seeking interim custody of the seized items or seized product. And we have got here various special criminal statutes under which also the respective IOs seize the thing. So I got the Forest Act, where I got the NDPS Act, where I got the Essential Commodities Act, where I got what you call Food Safety Standards Act, where I got also Arms Act. So like that, where I got so many special enactments which empower the corresponding officer or authority in question to seize the thing under the relevant provisions of the special statutes under criminal law. Whether in those cases the court can apply the same yardstick as under section 451 of Cr.P.C or not, or whether the provisions of the special statutes regarding custody of the property to be given, they prevail over the general principles of the Cr.P.C under sections 451 of the Cr.P.C. One more point is seizure of vehicles by the police, and for long the said applications are not ordered by the concerned courts, or there is a case of rival claimants. X says I am the owner, Y says I am the financier, Z says I am a prospective buyer of the vehicle. So in case of rival disputes or rival claims, the vehicles not within the precincts of the law courts or the precincts of the police stations. In that case, what are the guidelines of the Supreme Court of India? Seizure of narcotic drugs, seizure of contrabands, whether the special courts in the NDPS Act have the power under section 52 capital A of the NDPS Act or not, or whether the criminal courts or the special courts have no power at all to release a vehicle seized by the IO under NDPS Act. Can you apply the principles of section 451 Cr.P.C in case of release of a vehicle seized by the authority under the provisions of NDPS Act for its contravention? What about the aspect of seizure of a vehicle, seizure of a truck transporting sand without permit? And the act is Mines and Minerals Development and Regulation Act. Then comes the aspect of Essential Commodities Act. There, the Deputy Commissioner or the District Collector has got the power to release the seized vehicle. Whether the criminal courts can step in and pass order and direct the authority under the EC Act to deliver to the given person the custody of the seized truck as per order of a criminal court, as per order of JMFC or not. All these niceties we will discuss in the body of our brief study of 1 hour or 1.25 hour, and before that we'll take quickly section 451 of Cr.P.C that states that what court must do while considering the application filed by the applicant for custody of the seized item, seized property by the police pending further trial of the case. During crime stage, the police or the IO or the authority seizes the given property, and the applicant being owner of property may move the court. What court must do? So section 451 of the Cr.P.C states that the property seized by the police or authority should have been produced before the magistrate or before the criminal court, to clothe the criminal court with the power of passing order regarding interim custody of the seized vehicle or the seized product or seized property. So there should be production of the property before the criminal court in an inquiry or trial. What is called as inquiry? What is called as trial? We'll take it up at the next point. So the first point is there should be production of property by the authority or the police in case of commission of an offence. On section 457 of Cr.P.C, there is no production of property by the police or authority, but here it is mandatory. There should be production of property by the IO before the criminal court in an inquiry or trial, and thereafter the court can pass order as an interim measure pending conclusion of the trial of the main matter or criminal case. And if the products or property seized are subject to speedy decay or natural decay, and if the court cannot wait for long to trace the owner or to consider the rival claims of some applicants, the court may record evidence and dispose of the property which is subject to speedy and natural decay and credit to its account the amount of sale proceeds. Here the word property is defined as including any document also which the police seizes. So in a given case, the police seizes what is called as the passport of the particular offender under the Foreigners Act. They seize the passport. So a passport is called as a document, and that passport being a document is called as property for section 451 of the Cr.P.C. So property also includes a document which is produced before the criminal court by the concerned authority who seizes the same. So property of any kind or document which is produced before the court, and if they are in the court's custody, then the court has the power to grant or pass order stating as to whom it must be given as an interim measure. The second point is the court disposes of the main criminal case. While passing order on the main criminal case of acquittal or conviction of the accused, the court must pass further order or section 452 of Cr.P.C, 452 Cr.P.C with regard to the property, whether the interim order is made absolute or not. So the court must pass final order as to the possession or otherwise of the seized property, whether seized property is liable for destruction, liable for confiscation, or whether the court can pass order to deliver property to a given person. All these things the court must work out when the main case is concluded, and at that time it must pass a final order regarding disposal of the property because the proceedings get concluded. The third point is destruction of libellus or other matters on conviction of the accused for sections 272 to 275 of the IPC or sections 292 to 294 of the IPC. So if there is seizure of what is called as libellus and other matters by a publisher, the court may pass order for destruction of the libellus matter or materials or copies of the books as the case may be. In case of seizure of the drinks, food drinks, or drugs or medicinal preparations by a manufacturer of medicines, and the offences of sections 272 to 275 of the IPC, the court may pass order of destruction of the food, drink, drug, or medicinal preparations. The next point is section 457 of the Cr.P.C. So here the property is seized by the police and the seizure is reported by the police to the magistrate, and in this case the property is not produced before the court by the police. In 451 there is production of property. In 457 the property is not produced by the IO or by the police as the case may be before the criminal court during inquiry or trial. Then also the applicant to the concerned IA can move the court for release of the property even though the property seized by the police is not produced before the magistrate. And here the only point to be fulfilled is the police must report the fact of seizure to the magistrate, and if it is there, the matter ends. Then even though the property seized is not produced by the police before the magistrate can pass order as to whom the property should go as an interim measure. Then comes section 102 of the Cr.P.C. Section 102 states that every police after seizure of any property should report forthwith the fact of seizure to the jurisdictional magistrate for information. So today at 10 o'clock the police seizes a motor car in a criminal case. Car was used for transporting what's called as timber of the government of India. So there must be seizure of the property, and this fact of seizure must be reported by the concerned officer seizing it under section 102 of the Cr.P.C. The next point is what is called as inquiry, what is called as trial under section 451 of the Cr.P.C. Section 451 of Cr.P.C. speaks of trial, speaks of inquiry, and in this case the police seizes the property because of complaint, and in this case the court is required to inquire or try the case. So here the word inquiry is defined in section 2 subclause G of Cr.P.C. The word inquiry is defined in section 2G of the Cr.P.C. as meaning every inquiry other than a trial which a magistrate or a criminal court conducts with regard to a criminal case. So inquiry means every inquiry other than a trial. So filing of IA by the applicant for release of the property, that's called as inquiring of the matter. And here the police have not filed charge sheet. One charge sheet is filed and the court frames charge and posts matter for evidence of the prosecution. Then we say that the trial begins. So the word trial in section 2G is not defined in the Cr.P.C. Trial means upon charge sheet by the police before the court against the accused, the court framed charge informs the accused that on these lines the case will go forward, and we say upon framing of charge the case is set to be for the stage of the trial. So 2G of the Cr.P.C defines the word inquiry as meaning every inquiry other than a trial under Cr.P.C. So sections 451 and 457 of Cr.P.C deal with seizure of property by the police, and in the first case seizure is reported to the court and there is the thing being produced by the police before the magistrate. In the second case, the things seized is reported, but the factum of its production is not there in the second case. But in both cases, the court has to inquire, the court has to try the case, and then proceed forward. With this, we take quickly the case law of the apex court on various aspects of involvement of sections 451 and 457 of the Cr.P.C. We'll take a case of rival claims by RC owner of a truck and the rival claim made by the financier of the truck. Financier, say a bank, State Bank of India, advances loan to a loanee or a borrower to purchase a goods truck. And suppose, for example, this vehicle meets with an accident, or else the vehicle is stolen when in custody of the particular RC owner, and the vehicle is traced by the police. And before the court, RC owner moves the court to release the vehicle to him. The financier also goes to the same court and files application saying that give to me the vehicle's custody because there are dues of the borrower on the loan availed by the RC owner. So what about rights of the rival claimants in case of hire purchase agreement or in case of vehicle finance by a bank or a private financial institution to a borrower to buy a vehicle or a truck or a car as the case may be. Here the first case is Charanjit Singh Chada versus Sudhir Mehta, 2001, Part 7, Supreme Court Cases 417, Sections 24, 406, 420, 120B, 378 of the APC, and Section 451 of the Cr.P.C, and also Sections 8 and 20 of Hire Purchase Act. In this case, the question involved was to whom the criminal court must give the interim custody of the seized vehicle which was stolen as per the complaint of the RC owner. In this case, the Supreme Court held in clear words that even though the RC owner finds his name in the certificate of registration, but still the apex court held that under Section 2, Suppose 30 of the Indian Motor Vehicles Act of 1988, it is the financier which is the owner of the seized vehicle because it has got its charge on the vehicle seized. In this case, the apex court held that the RC owner, as per the RC book, cannot claim the vehicle's custody in the trial or inquiry, and in case of rival claims by the RC owner or the borrower of the concerned vehicle, and also the financier or the company which financed the vehicle on hire purchase agreement HPA, the apex court held that the vehicle must be given to the financier and not to the RC owner because there are still dues of the amount to be paid by the principal borrower with regard to the loan transaction. So this is the first case of the apex court on the aspects of rights of RC owner and rights of the financial or financial institution, or in case of hire purchase agreement, what about the rights of the parties? That is the case of Charanjit Singh Chadha versus Sudhir Mehta. The second case is Damodar Valley Corporation versus State of Bihar, AIR 1961, Supreme Court, page 440. In this case, the apex court held that in case of a hire purchase agreement, it is in fact the one who gives the property to the hirer for use. He is called as the the hire purchaser, and on fulfillment of terms of the HPA, he becomes the full owner of the property. The apex court held that third party rights are created as per law in case of hire purchase agreement, even though the name of the hire purchaser is shown in the RC book as the RC owner, and name of the financier is stated as the person who gave loan as per the hire purchase agreement. The next case law is K.L. Johar and Company versus CTO, AIR 1965, Supreme Court, page number 1082. Here also, the apex court held that in case of hire purchase agreement, it consists of firstly element of bailment and secondly element of bail, in the sense that there is a further sale of the vehicle or property once the particular borrower or hirer fulfills the terms of the contract. That is case of K.L. Johar and Company versus.
So you have closed your video somehow. Yeah, it's fine. No, again closed. Yeah, no, it's fine.
The third case is Sundarbai Ambalal Desai versus State of Gujarat. Very, very important case. That is 2002, Part 10, Supreme Court Cases, page 283, Sections 451 of Cr.P.C and Section 457 of Cr.P.C. Disposal of Muddamal articles kept in police custody pending trial. In this case, the facts involved were that seized gold ornaments kept by the police in the police station, seized by the police in a criminal case, they were replaced by the police machinery by keeping inside spurious ornaments, duplicate ornaments. So, in this case, gold ornaments seized in a criminal case by the police were not produced before the criminal court. Number two, they were replaced by the police only by keeping inside the seized what you call box spurious things or duplicate ornaments. So in this case, the apex court laid down various guidelines which the trial courts must follow in case of seizure of what's called as precious stones, gold, silver, currency notes, vehicles or liquor, narcotic drugs, etc. The apex court laid down various guidelines, and at para number 7 it laid down 4 important guidelines to be followed by the trial courts, to be followed by the police. The first point is the principles on which this case law is developed is owner of article should not suffer because of its remaining with the police or the court for long. With the police they lie for 1 year, or in the court they lie for 1 year, the first point is owner of article would not suffer because of its remaining unused or by its misappropriation. In the court's hand also, the property may just be stolen. Before the police also, the thing may get disappeared. The second point is court or the police would not be required to keep the articles in safe custody for long time. Say for 1 week, I can keep it. For 2 weeks, I can keep it, but not for long. The third point is if proper panchanama before handing over portion of the seized article is prepared, that panchanama will serve as a document of seizure stating its description, its valuation, and all those things. So in this case, keep with you photocopy of the seized articles or keep with you videograph of the seized articles, prepare panchanama and hand over property to the concerned RC owner or the concerned owner of the jewels as the case may be, and if necessary, evidence can be recorded by the court describing its nature in detail. The fourth point is this jurisdiction of the record in the form of evidence should be exercised promptly and there should not be long delay on the part of the particular person. So here the important point is namely these are the four important parameters which the Supreme Court observed at parameter 7 of the judgment. At parameter 12 of the judgment, the Supreme Court also laid down important guidelines. Prepare detailed property panchanama of the articles seized, maybe gold or silver or currency notes or even what you call intoxicants or liquor, the case may be. Take photographs of such articles and take a bond from the person in question to the effect that he will produce the same before the court during trial. The third point is take proper security from the person. Go back to RC owner, the vehicle, go back to the owner of jewels, the gold ornaments, take from her or him a bond, indemnity bond, with surety as the case may be, and those things the Apex Court laid down in the above particular case. At paragraph 14 of the judgment, the Apex Court also stated that in case the properties are not given to the complainant or to the person from whom it is seized or to the rival claimant before the court, then the Apex Court passed order saying that the property can be sold and the amount be recovered and kept in the bank, or if the properties cannot be sold or if they are to be retained, keep them in bank lockers. Don't keep them in the lockers of the concerned police station, locker of the concerned court. That is called as safe of the court. So they passed order, retain them in bank locker by the police or the magistrate. They can keep it for 1 week. If it is beyond 1 week, then they say keep it in bank locker. And for courts, the system is court seizes the property, gold ornaments, or currency also. It won't retain it with it for more than even 24 hours. On the same day, by afternoon, the property seized, being very valuable, they are lodged by the court in the office of the treasury office of the concerned state government. So treasury offices are there at taluk level, district level, and they lodge it in the treasury office in the safe custody of the treasury. That is the aspect of the practice of the trial courts to whom the police produces valuables, gold ornaments, or silver ornaments, or studded articles, or ornaments, even currency also, as the case may be. One more point is, in case of seizure of vehicles, the Abbas court held, give back to the RC owner. In case of no other rival claims, forthwith, take bond, put conditions, don't keep the vehicle in the police station or in the court. If there are rival claims, you decide as to whom it can be given and then go forward. And if no claimants are there to take the vehicle, then issue order of proclamation, issue notice to RC owner, notice to insurance company, notice to other person, as the case may be, financier. If nobody appears, issue proclamation, fix date for sale, sell it, and put the amount in the account of the court. In case of other items also, the Abbas court laid down various guidelines. So I will not take much time on the case of Sundarbai Ambalal Desai versus State of Gujarat. It's a case of 2002, Part 10, SCC, page number 283. This is the Bible for the trial courts, in my opinion. This case law is of the year 2002. It is now a 2-decade-old case law, but still, based on ratio of this case, the trial courts pass order releasing property in favor of the persons who are to be given portion of the property. The next case is police seizes gold ornaments and police reports the matter to the concerned court. And court passes order, retain gold ornaments with you until filing of charge sheet. Because in case of theft of gold ornaments, police says we want to keep it with us, because if the owner makes claim, we have to show to him the gold ornaments for purpose of identification. And in this case, the police may say that they require the particular thing with them, gold ornaments. In this case, huge cash and large number of ornaments, gold ornaments, silver ornaments, worth more than rupees 10,000 were seized by the police in 1958. So it's a case of nearly, 60 years, 6 decades old. So in 1958, in the night of November 28 of 1958, there was theft of huge cash, gold ornaments, etc. from house of the complainant. And her name is Srimati Basava, wife of Damanagoda Patil. It's a case of the police station of Haveri, that's a district place in the state of Karnataka, that is abutting the National Highway number 4. And there was seizure of, and there was theft of these huge amount of cash and large number of ornaments. So she lodged complaint before the police, and police seized the same from the thief, and the thief was booked. Upon seizure, the court directed the police to retain with them until they file charge sheet. So these things, they remain with the police or in the police station, because the police was required to show these seized ornaments to the complainant for purpose of identification. And it so happened that 5 accused were traced, and from them they seized cash and gold ornaments, etc. And the police had reported to the concerned magistrate the fact of seizure of gold ornaments from the hands of the 5 accused, and the CJM of Haveri directed the police to retain the seized articles with it and to get the value of gold ornaments determined by a goldsmith, and for that requires time to examine the gold piece by piece. They have to weigh it, they have to see its purity, so that takes even a week or 2 weeks. When the articles were in the control of the PSI of Haveri police station, and they were in the guard room of the police station, and they were in a trunk, and after some time the PSI was transferred and the new PSI came. The new PSI, while taking charge, wanted to take custody of these gold ornaments which was in the trunk, and to his surprise, in the trunk there were no gold ornaments. There was no cash which the police has seized from the particular 5 accused in the criminal case. Then the PSI who took charge reported matter to the higher ups, saying that I took charge today and I could not take possession of the seized gold ornaments, and reported the lapse on the part of the previous PSI, because gold ornaments, cash kept in the sealed trunk in the guard room of police station, it did not contain those items. They contained some other papers. In fact, they contained some stones, as per the case law, which the facts is being stated. There were what's called as finding of stones in the particular trunk, and this particular woman, the complainant Damava, applied to the magistrate at Haveri for release of the seized item, seized gold ornaments, and police filed objections saying that this article is not with them, and the magistrate held that the articles were not produced by the police before the court, but that they had filed only the report, and court had permitted the police to keep the things with it for purpose of investigation. And since the articles never reached the custody of the court, the magistrate held that it has no power to pass order for granting custody of the seized gold ornaments and cash by the police from those 5 accused persons. So the owner of gold ornaments suffered a negative order. Then she applied in revision to the Court of Sessions. It also dismissed the revision petition filed by the complainant. Thereafter, the matter went to the High Court. High Court also passed order saying that these ornaments, though seized by the police, and though the court had directed the gold ornaments to be with the control of the police, and since they are not in the control of the court, the order of the two courts below are proper. So the complainant approached Supreme Court of India. I have lost my gold ornaments. I have lost my currency notes, and police had seized the same. And in the police custody, when they were there was replacement of ornaments and cash by stones. So the Apex Court held that the magistrate committed illegality in dismissing the EA filed by the owner of the gold ornaments. The Apex Court held that the fact that the seizure of the articles, gold ornaments, was reported by the police to the magistrate, and the magistrate passing order stating that you retain with you these ornaments until you file charge sheet and until you get completed the work of getting valuation of the properties, the Apex Court held that custody of the property does not mean physical custody or possession of the property. If the court is given the application by the police or the concerned IO to the fact that we have seized a given thing, and if the court passes order, retain these seized properties with you until filing of charge sheet, the Apex Court held that custody does not mean physical delivery or possession of the ornaments or things or articles or property by the police to the court. In this case, the Apex Court held that the Magistrate Court, the Court of Sessions, and the High Court committed illegality. It held that the magistrate should have passed order allowing the application, even though the property was not there. He could have passed order, determine its value, and ask the police machinery to pay to the complainant the value of the lost ornaments. So, in this case, the Apex Court came down very heavily on the trial court, the Court of Revision, the High Court. At para 7 of the order, the court observed that value of property stolen was rupees 10,000. It directed the state government to pay to the complainant rupees 10,000. This is the value, say 64 years ago. So now it must be a fortune amount. Then also a fortune amount. So the Apex Court held that at Paris 1, it held that the state government shall pay to the complainant rupees 10,000 being value of the property which was lost by the police in its guard room at Haveri police station. And you have time of 3 months to the concerned police to pay the amount of rupees 10,000 to the complainant. So this case law states in clear words that in case of loss of the properties at the hands of the court or at the hands of the police, and if the factum of seizure is reported by the police to the magistrate, the matter ends. The magistrate has got the power to pass order regarding custody of the seized thing. If they are lost means the court has to direct the police or the wrongdoer to pay to the person who is the owner its value or cost of the property, so misappropriated or so lost as the case may be. That is the case of Srimati Basawa, wife of Damangoda Party versus State of Mysore, 1977, Part 4, SCC, page number 358. So with this, I have discussed the aspect of rights of the financier versus rights of RC owner, rights of owner of an item, owner of property which is seized, being lost when in police custody or when in custody of the court. He can get what's called as the value of the property which is lost. The next case now is State of MP versus Rameshwar Rathod, 1990, Part 4, SCC, page number 1849, Sections 6, capital A, subclause 1 and 7 of the Essential Commodities Act, and Sections 451 and 457 of the Cr.P.C. So under the EC Act, the Deputy Commissioner or the Collector of the district has got the power to release the property seized by his authorities or his inferiors. So the Collector of the district has got the power to release the seized truck, say transporting wheat without permit or transporting wheat of a fair price shop. So wheat or rice, etc., which was meant for sale through fair price shops, Now we know these black marketers, they just buy from the fair price shop owner. Fair price shop owner will not sell them to the ration card holders, and this particular container was seized containing wheat in a given case. So seizure of truck was there by the officer under the Essential Commodities Act. And there the provision is the applicant can move the court, move the deputy commissioner or collector for release of the seized vehicle or seized thing as the case may be. So whether that particular power given to the collector under the AC Act, can the magistrate exercise or section 451 of Cr.P.C or not is the question involved. So in the case of state of MP versus Rameshwar Rathod, the apex court held that even though the Essential Commodities Act state that any person whose vehicle is seized by the authority under EC Act has to move the collector for release of the said vehicle, so seized by the officer under the EC Act, but still the power of the criminal court is not completely ousted under section 451 of the Cr.P.C. So the apex court at para 6 of the decision observed that normally under Cr.P.C, criminal courts of the country have the jurisdiction, and ouster of the ordinary criminal court in respect of a crime can only be inferred if that is the conclusion following reading of the act. EC Act did not say or does not say anywhere that criminal courts of the country cannot grant a release of property. It states the owner can move the DC or collector for release of the vehicle, but since the EC Act does not contain what is called as a specific covenant that criminal courts have no power to deal with the matter, the apex court held that criminal courts of the country have the jurisdiction, and ouster of jurisdiction must be specifically stated in the body of the special statute. So the apex court held that order of the magistrate has got the power to order for release of the seized vehicle under provisions of section 6 and 6 capital A of the Essential Commodities Act. So with this, it's taken you through the case law of the apex court on the Essential Commodities Act. The next point is Wildlife Protection Act 1972. Seizure under Wildlife Protection Act, whether the criminal courts have got the power or whether only the forest authorities under the Wildlife Protection Act have got the power. The case law is state of UP versus Lallu Singh, Lalloo Lallu Singh, that is 2007 part 3 crimes, Supreme Court, page 224. So in this case, the apex court in the case of Lallu Singh observed that under sections 50 surplus 1 of the Wildlife Protection Act read with 39 of the Act, in this case the officials empowered under the Wildlife Act have got the power to release the property seized, and in case it states that the officer under the Wildlife Protection Act should form proper opinion as to whether the property seized becomes property of the state government or not. If it holds that the property becomes property of the state government and that that property was used by the accused to commit the offense, then the magistrate has no power to release the thing seized by the authority under the Wildlife Protection Act. The first court held that the magistrate has to see if the official had formed belief on reasonable grounds that the person committed the offences under the Wildlife Act. So, if the officer of the Wildlife Act forms opinion that the seized property become property of the state government, then magistrate has no power. If he does not form opinion that the property seized is not property of the state government, then magistrate can step in and can pass order. That depends upon nature of formation of the opinion by the authority under sections 39 and 50 of Wildlife Protection Act of 1982. So with this, the next point is namely the case law of the Apex Court, Intercontinental Agencies Private Limited versus Amin Chand Khanna and others. Sections 451 of Cr.P.C is involved here. Here, the facts involved in the above case is namely there was loss of the property seized by the police, and in this case the Apex Court held that if there is loss of property seized by the police either in the custody of the police station or before the court, as per decision of Supreme Court of India in Basava versus State of Mysore, as told by me previously, the concerned applicant must receive the value of the property so lost or so misappropriated. So the case of intercontinental agencies is again a case involving the same ratio of Basava, Kom, Damanagoda, Patil versus State of Mysore. So in this case, there was seizure of bus. Upon seizure of bus, the bus was stolen. The bus was not recovered at all by the police thereafter. So the RC owner of the vehicle moved the court, give me the bus. And the police informed the vehicle is not traceable, vehicle is stolen. As we know, once the vehicle is stolen, the concerned persons, they just separate all the parts, and even they sell separately the doors, the windows, even the seat panes also, as the case may be, and even they may just convert the entire body of the concerned vehicle as a sheet, complete sheet. So there is total loss of the particular vehicle. Vehicle was not traced at all. The Apex Court held that owner of vehicle must get the value of the vehicle which was with the police in their custody and from which there was theft of the seized bus by the thief and the vehicle not being traced by the concerned police in spite of taking sufficient steps. So with that, the next important case law on the above point is the case of Ashok Kumar versus State of Bihar, that is 2001 Part 9 Supreme Court cases page number 718. In this case, a vehicle seized by the police was rotting in the compound of the court complex for number of years. Vehicle was seized by the police, and the police upon seizure produced the vehicle before the concerned court, and this vehicle was rotting in the compound of the court for number of years. Maybe the RC owner might not have just might have now approach the court for its custody, or the banker may have just also kept quiet, or if there is no bank finance, then in case of severe offences, nobody will come to claim the property. If the claim means, then they admit that they are the culprits. So there was no claim of the seized vehicle which was lost in compound of the court for a long number of years. The Apex Court directed the trial courts in the country, as per para 2 of the above order, saying that court must not keep with it a vehicle in its court compound for a long time till disposal of the main criminal case, and it must release property to the RC owner with conditions. If he is not there, means take steps, issue a proclamation, sell it, recover the amount, and you can take the further steps. That is the case law of Ashok Kumar versus State of Bihar. So with that, the next important case of the Apex Court is namely State of Karnataka versus K. Krishnan, that is 2000 Part 7 Supreme Court cases, page number 80, sections 71 capital A of the Karnataka Forest Act. So various special statutes have got separate sets of procedure regarding release of the seized article. So in this case, the Apex Court at para 7 observed that if any vehicle is seized on the allegation by the IO that it was used for committing a forest offence, the Apex Court held the same shall not be released in favor of the RC owner also until the main case is over. So no question of release of the vehicle seized by the officer under the Forest Act if it was used for commission of a forest offence. The Apex Court held that wait for disposal of the main matter. Until then, don't release the property, the vehicle, because under the Forest Act, the power is there for the court to confiscate the vehicle to the state government. So, at para 7, the Apex Court ordered that when any vehicle is used, is seized by the accused, by the authority for committing a forest offence under the Forest Act, the same shall not be normally be returned to a party until all the proceedings are over, including proceedings of confiscation. It held that in fit cases, a court is inclined to release a vehicle to a person in custody. It must take bank guarantee. Don't take simply bond. Take for the vehicle's value bank guarantee with sureties for the like sum. So you want to release with a rider. Take from the RC owner bank guarantee, but not a simple bond. That is the ratio of State of Karnataka versus Krishnan, 2000 Part 7 Supreme Court cases, page number 80. So I have discussed case law of the Special Acts, Forest Act, case law of Wildlife Protection Act, case law of Essential Commodities Act, case law of Hire Purchase Act. See, we have got there separate sets of rules, and there in some cases, as we have discussed, Cr.P.C has no application. The next question is, if the property seized by the police in a criminal case is not produced before the magistrate, can the magistrate has got the power to release such property which is seized by the concerned police but not produced before the court? Here comes section 457 of the Cr.P.C. The case law is Ram Prakash Sharma versus State of Haryana, 1978, Part 2, Supreme Court Cases, page number 491. So, in this case, police recovered huge sum of money from the appellant and the same was seized. And in this case, the said seizure was reported by the police to the court, but the cash amount seized was not produced before the criminal court. So the criminal court held, the Supreme Court held that the magistrate has got the power to order for release of the seized property. In this case, the currency notes seized by the police were missing. So the Apex Court held that the owner of the said currency notes or the complainant must be given the amount of money which was misappropriated because of act of the police. So even though the property seized was with the police only, and the property seized was not delivered by the police before the magistrate, but still the magistrate has got the power to release the property, and if they are lost at the hands of the police, the court can direct the police to reimburse the amount so lost or misappropriated by the concerned police. So this, the next important case law of the Apex Court is namely Sajan K. Varghese versus State of Kerala. Sajan K. Varghese versus State of Kerala, 1989, Part 2, Supreme Court Cases, page number 208. In this case, there was seizure of semi-finished films of a film which was being shot up to 90%. So the police seized what's called as the video of a film which was shot to the extent of 90%. And this particular video containing shooting of 90% of a Malayali film was seized by the police in a criminal case lodged against Sajan K. Varghese, who is producer of a film in Kerala. So this Varghese had borrowed huge sums of money from various investors by saying that I will invest your funds in producing a film, I will give you very heavy returns. And many depositors, they deposited their hard-earned money in deposits with this Sajan K. Varghese. And at the end of the day, the Sajan K. Varghese did not return to the depositors the deposit amounts, and they filed complaints, and Varghese was arrested by the police, and the police seized what's called as semi-finished film roll of a Malayali film. And in this case, the Apex Court held that semi-finished film roll is not a property under Section 451 of the Cr.P.C. because until the entire film is shot in full and the film is ready for exhibition before the public in a theatre, the Apex Court held that seizure of a film in a case of complaint against Sri Varghese by the investors of their monies, police could not have seized the particular semi-finished film roll. In this case, it directed the trial court to release to the particular person what's called as semi-finished film roll in this case. So I discussed as to how the scope of the word property was used by the court in case of Sajan K. Varghese versus State of Kerala. It's a very important case touching some niceties of law. So with this, the next point is Ramesh Chand Jain versus State of Haryana. That is 2007, Part 13, Part 15, Supreme Court cases, page number 126. In this case, whether a criminal court can decide rights of rival claimants involving a civil dispute or not. Whether criminal court has got a power in a criminal forum wherein two persons have laid claim on the property seized. Say a vehicle is seized. I say I am the RC owner. X says he is the RC owner. M says I am the buyer of the vehicle from the seller. So whether the criminal court has got the power to decide on inter se disputes between rival claimants, that is RC owner of truck, the bank as financier, guarantor and borrower disputes, or even in case of a buyer of a vehicle buying the vehicle from the seller, even though loan amount is due on the said vehicle. So in this case, the Apex court held that rights of rival claimants, which is purely civil in nature, the criminal court cannot embark on a trial. So the criminal court cannot decide inter se civil liabilities of the parties, maybe RC owner, the banker, the financier, the guarantors, as the case may be, and bank must pass order only giving the interim custody of the seized vehicle as an interim measure. Court has no power in the criminal forum for release of property, what's called as inter se civil liabilities between the RC owner, the principal borrower, the banker or financier, and the guarantors. So with that, the next case law is State of MP versus Madhukar Rao, that is 2008, Part 14, SCC, page number 624. It's a case of Wildlife Protection Act. So, seizure of vehicle by the Forest Authority for commission of offence under the Forest Act, sections are 50, subclause 1, subclause C, read with 39 of the Wildlife Protection Act. The Apex Court held that the magistrate has no power to order for release of the seized vehicle. On section 50, subclause 1, subclause C of Wildlife Protection Act. So, these case laws, they just tell us how special criminal statutes, they have got special law, and how the particular regular criminal courts have no power to release the seized property. The next case is State NCT Delhi versus Narinder, 2014, Part 13, SCC, page number 100. It's a case of Delhi Excise Act. In this case, a vehicle transporting liquor bottles was seized. As per Delhi Excise Act, the authority to release the vehicle is the officer under the Excise Act, but not the criminal courts. So the Apex Court held that because being a special statute, the Delhi Excise Act stating that the RC owner can move the authority under the Excise Act, but not the court, the Apex Court held that JFC Delhi has no power to release the seized truck which was seized by the authority for illegally transporting liquor bottles. So with that, I completed the aspects of case law of the Apex Court on important aspects of the law, and I have got also some more case law on the point, but still Because of lack of time, I cannot proceed further. I will take only last two case laws. Nevada Properties Private Limited versus State of Maharashtra 2019 Part 20 Supreme Court Cases page number 119. So in this case, power of seizure under sections 102 and 457 does not extend to immobile properties. So, property used in sections 451 and 457 means only properties which are movable, including documents, but not properties which are immovable. So, a person being owner of property which is immovable cannot move the criminal court, asking criminal court to give to him the custody of the portion of the property immovable, even as an interim measure. So, the apex court observed that the word produced in sections 457 and 102 of the Cr.P.C means actual or physical production which would apply to property movable, and immovable property cannot be produced in a court. That is the case law of the apex court in the case of Nevada Properties versus State of Maharashtra 2019 Part 20 Supreme Court Cases page number 119. So last case law is case law of NDPS Act, Section 52 capital A of NDPS Act. So the authority under NDPS Act or the police under the general statutes seizes a vehicle, a car transporting narcotic drug. So seizure of a car by the police, local police or authority under the NDPS Act, and the vehicle was used to transport what is called as narcotic drug. Whether the criminal courts have got the power to release the said seized property or not is the question with which we are concerned. The question is whether the regular criminal courts have got the power to release seized vehicle used by the accused for commission of offence under section 52 capital A of NDPS Act or not. Here the case law of the apex court is there on the above point. That is 2016 part 3 Supreme Court cases page 379. Union of India versus Mohanlal and another. So the case of Mohanlal, that is 2016 part 3 SCC 379 state that regular criminal courts, magistrate court, special court under NDPS Act, they have no power to order for release of vehicle seized by local police, seized by the office under NDPS Act, which was used by the accused to transport narcotic drug under section 52 capital A of NDPS Act. Criminal court has no power at all to release a car or vehicle or container used to transport narcotic drug. And the question is, before whom the RC owner should move the court, should move for release of the vehicle seized. Car is seized. Okay, criminal court has no power. Then which court can grant the vehicle custody? It is Drugs Disposal Committee. They have got an authority called as Drugs Disposal Committee. Before that committee, the RC owner should move application for release of the seized vehicle under 52A of NDPS Act for release of the seized vehicle. In the case of It's a case 5 years old. That is 2016, Part 3, Supreme Court Cases, page number 379. Para number 31, 31.1, very important. Disposal of property, even interim also, only by drugs disposal committee, but not by magistrate or by the special court for NDPS offences. So with this, I completed the brief study on the aspect of case law of the apex court under Cr.P.C, under special criminal statutes, as to how in some cases Cr.P.C section 451 has no application. So courts cannot pass order in a casual way when they deal with aspect of special statutes. So see the special statutes, see the case on the point, and then go forward. The advocates also should know sharply in which case their application will be liable to be allowed, and with regard to the other aspects, and if the court does not know properly what the law is, advocate should empower the court. Because as you all know, nobody is perfect, nobody can claim that they know everything. Even the apex court appoints amicus curiae. For what purpose? Because it wants expertise from an expert in a given field. Because on that aspect, the court may not have all the important inputs. So with this, I conclude my talk on the aspect of seizure of property, seizure of documents, seizure of vehicles, seizure of prohibited articles, drugs, as the case may be, even intoxicating liquors, and with regard to rights of financier, rights of RC owner, rights of third party, loss of the item seized when in the police station or in the court, duty of the court to direct the police to return to the applicant, owner of the vehicle, its value, as the case may be.
On chat right now, we don't have any question as such, but on YouTube, yes, we have. Sir, could you explain the difference between section 451 and 457 and whether these are orders are interlocutory? And if so, whether these orders are revisable or not? Hello? Hello? Hello?
There is property.
So it says what is the difference between section 451 and 457 and whether these orders are interlocutory. If so, whether they are revisable.
Now, order passed by the court on IA is called as an interlocutory order. And on the interlocutory order, revision lies to the Court of Sessions on section 450, under section 397 of the Cr.P.C.
Yeah.
So there is a order, the Court of Sessions, the order being passed by what's called as the trial court, JMC court. Order passed by the special court of the rank of a Court of Sessions, then the matter is in revision to the High Court. So that depends upon the forum. So 451 is a case of passing of order by the court, which is what is called as interlocutory order. And I regard section 459 of the Cr.P.C, power to sell perishable property if the person entitled to is not known or is absent and the property is subject to speedy and natural decay, or if sale is for the benefit of the owner. So when the court can sell property, if there are perishables and the owner is not known, that is section 459. But the answer is order of the court on IA for release of the property is an order which can be revised before the court of revision. It may be a court of sessions or it may be the high court as the case may be.
In a POSCO case for the release of vehicle, the court sends notice to the complainant. Is it mandatory?
Is it?
Mandatory sending a notice to the complainant.
There is no need for the court to inform the complainant that they are hearing the matter. Say, in a criminal case, the property is seized by the police. The property seized is, say, namely a vehicle. The complainant is injured. He files complaint. The vehicle is seized by the police. The RC owner moves the court for release of the vehicle. So only the state and the RC owner, they are the parties with which the court must hear. The victim or the complainant, his interest is taken care of by the court, by the state only. So the victim has no right to be heard under Cr.P.C for release of the seized article or seized item. Because in case of complaint of the victim, the state machinery enters and the victim, his rights are protected by the state only.
He's saying, how would it be divisible in view of the bar under section 397 that no revision lies in an interlocutory order?
But see, in some cases, the point is that some courts have held that order passed by the magistrate is not a order which is revisible, but still at the end of the day, the court is required to pass order as to whether the IHT is to be allowed or not. At the end of the day, the matter may go to the High Court, that's all. As to whether the right of a party to a given thing seized will culminate into right at the main end of the case or not is not a main issue. But we have got case law of the apex court also, case law of high courts also, which states that order passed by the magistrate court allowing or disallowing IA filed by any person for interpretation of the vehicle as the case may be is a order which is liable for revision before the court of sessions. And we got here the case law of our High Court also on the very same point. That is a case of the High Court of Karnataka in case of seizure of narcotic drugs under the provisions of NDPS Act, and it is in fact an unreported decision of the High Court of Karnataka. In this case, the case is Jubaida, wife of late Muhammad Ali versus Narcotic Control Bureau, NCB, Bangalore. Criminal petition number 3792 of 2020. Date of order is 24/11/2020. In this case, vehicle seized by the officer of NDPS at Bangalore. That vehicle contained narcotic drugs. So the RC owner of the vehicle, RC owner is from Kerala. He moved the special court after rank of session judge at Bangalore City, court hall number 33, for release of swift car seized by the authority under NDPS Act. The said court, special court of NDPS Act, dismissed the IA filed by RC owner on the ground that it has no power. Then the RC owner moved the court in criminal revision petition but not criminal appeal, because the case title is Criminal Petition number 4792 of 2020. And even the High Court passed order stating that revision petition is maintainable. It held that in view of decision of the Supreme Court of India, which I told previously of the year 2016, it held that magistrate or special court has no power to order for release of the seized vehicle, and it directed the RC owner to move the drugs disposal committee under NDPS Act at Bangalore for release of the seized vehicle in this case. Our High Court placed reliance on decision of Mohanlal case of that is 2016 part 3 SCC page number 379. So order passed by a court on IA under 4 of Cr.P.C is revisable. Now this is a what you call a mind-boggling exercise. Looks very simple, but when we lay hands before the court involving special statutes, then comes the main difficulty. Regular cases, accident cases, seizure of bus, seizure of car, very simple. But these special statutes, they have prescribed special procedure to even give the property back to the owner, even as an interim measure.
Says under Section 143A of the Negotiable Instrument Act, how can Section 451 of Cr.P.C be invoked to execute the interim compensation?
Now, 143 capital A of the NI Act is introduced in 2018. There, the offence is under section 138 of the NI Act. Check was issued, check bounced, and the complainant complies the procedure of giving notice, then no amount is paid, then it files before the criminal court, what's called as a private complaint on section 200 of Cr.P.C. So here, interim compensation, the court can pass if the complaints are lost from and after, I think the date is 1/9/2018, if I'm correct. So if it is there means, as an interim measure, the court can direct the accused to pay to the complainant, the person whose check was bounced because of the respondent accused not keeping in his account balance. So, and this particular complainant has to execute a bond before the criminal court saying that in case my case at the fag end is held as not maintainable, or if the accused is acquitted of the charge of Section 138 of an Act, the court will direct this complainant to return to the accused the amount which the accused had paid to the complainant as an interim compensation under 143 capital A of the Act. So this 143A cannot be tagged with section 451 of the Cr.P.C. And if the particular complainant does not pay to the accused the amount which was paid to him as interim compensation, then under the Act only the amount can be recovered. As arrear of land revenue, they are given there the procedure under the Act 143A. Even in appeal also it can grant interim compensation. They have fixed up the scale. They got their case law of the apex court on the above point also. But we cannot link 143A of an Act with section 451 of the Cr.P.C. And in fact, an Act is what is called as a semi-civil nature trial. Even though it's called as a crime under an Act, but its scope is as if there is trial of a civil case. And there, the purpose of an Act is to restore to the complainant the amount of check which was dishonored. That is the main purpose. Not to penalize the accused person. Even though he is called in law as an accused, but still he is of the rank of an opponent or a defendant in a regular civil case.
So we have taken the questions now. Yeah, right now I thought it's over. What is the procedure of releasing the seized vehicle under the Section 3358 of the Delhi Excise Act? I don't know whether you would be able to handle Delhi Excise Act.
There, Delhi Excise Act was invoked by the authority under the Excise Act. A truck was transporting illegally this liquor. Liquor was transported without permit, or it may be liquor which was stolen without any permit or without any invoices. In this case, as per Delhi Excise Act, they have got the authority who has got the power to release the seized vehicle for contravention provisions of the Delhi Excise Act. The Apex Court held that when special statute states the officer who has to be moved for release of the seized vehicle, then that remedy only must be exhausted. Criminal courts have no power. It held that JFC Delhi has no power to release the seized truck which was seized by the authority under the Delhi Excise Act, it being a special criminal statute. In case of special criminal statutes, those provisions prevail over provisions of the Cr.P.C, Section-451 of Cr.P.C.
So thank you, sir, for sharing your insights. And we just thought that you will be taking us to the gamut of 451 and 201 particular act, but you have taken us to the wide spectrum of the knowledge. We're indebted for that. And tomorrow we will be having a session on impleading, abatement, setting aside of abatement, and condonation of delay. That is, we will be discussing our Order 22 of Code of Civil Procedure Code. So do join us. Justice K.T. Sankaran, a former judge of Kerala High Court, and the former chairman of the Kerala Judicial Academy would connect with us at 4:30. So do stay connected with us tomorrow. And thank you, sir, once again. Thank you.